Okay, Susan.
Court is now open. You may be seated.
TAL Financial Corporation versus CSC.
Okay, Mr. Singer, you're up.
Thank you, Your Honor. May it please the Court, I'm Leonard Singer, here this morning on behalf of TAL Financial Corporation. Mr. Howard Siegel, who's the principal of TAL, is in the courtroom. The case before the Court this morning arises out of a series of leases for personal property. The lessor seeks to enforce two provisions in those leases. First, it seeks to enforce a so-called automatic renewal provision, which provided that the lease term would be renewed for successive one-year periods if notice of termination were not given 90 days before the end of the lease term. And the issue that was tried in the Superior Court was when was that notice given. The second issue, or the second provision of the leases which the lessor seeks to enforce, is a liquidated damages provision, which provided for 18% of the purchase cost in the event that the lessee failed to return the leased equipment. After a jury-waived trial, the Superior Court judge found in favor of the lessor as to the question of when notice of non-renewal had been given, but we submit that she miscalculated the amount of rent that was due. The Superior Court judge also determined that the liquidated damages provision was unenforceable because she said it was unreasonable at the time that the contract was entered into. What I'd like to do this morning is deal briefly.
Let me just interrupt you. What was your theory as to how the lease was terminated? Was it terminated by default, or was it terminated by a notice of termination by the tenant, the lessee?
I think it's fair to say that our theory at trial was that it was terminated by an October 2001 letter received from the lessee. The judge found, and we don't quarrel with this finding, that it was actually placed in default a month earlier in September.
Okay.
And I think the word she used was that we waived, by that notice, we waived the requirement of any further notice of termination.
Could you just, as I read this, while the judge rejected the equitable defenses, she characterized that as a close call. And as a close call, even when she was just looking at the 48-month, the 4 years. The equitable defenses here surely get stronger when you're trying to tack on a fifth year, don't they?
No, I don't agree with that. And I don't. The judge's characterization of a close call was on the issue of bad faith. I think she categorically rejected the affirmative defenses of waiver, estoppel, and things of that nature. But no, I don't think so. And she did reject them. I mean, close call, not close call, they're gone. She did find that.
Well, I mean, I guess what troubles me, and I understand that the defendant here is not appealing her decision that it did extend to the fourth year, so they're not appealing it. But as I take it, we've got a March 2001 letter announcing an intent to pay off the account in full, requesting information to do so, and at that time the defendant had already notified your client that the equipment had been discarded. So why would anybody extend a lease of equipment that has already been discarded? I mean, it's just nonsensical. And it's one thing to say, okay, you know, you're still stuck for the fourth year, but to say you're stuck for the fifth year when the plaintiff, the lessor, the finance lessor, already knows it's been discarded.
Well, Your Honor, as you
do you know
said,
anybody who would extend the lease of equipment that they don't have anymore?
well, they did. I mean, that's what this contract says, and it provides for written notice. We were dealing with a sophisticated, a very large corporation.
You get written notice. We want to pay it off in full, and you know, and you already know that you've discarded it. That Sure sounds like a desire to terminate the relationship and terminate the lease to me.
Well, they didn't pay the amount. They didn't question the amount. I mean, the judge did determine that the amount set, the payoff figure that the lessor provided was inaccurate. But if they were making an offer to do that, they didn't perform upon that offer. They didn't question the numbers. I mean, I think it's significant here that the Superior Court judge, when she rejected the bad faith defense, essentially she relied on the fact that the request for the lease, that the manner in which the lessee dealt and paid attention to this transaction was hardly urgent. That yes, there was a request for a copy of the lease, but it was never put in writing, and there was other evidence at trial which suggested that the lessee didn't really pursue or seriously evidence its desire to do anything about
Fine. So
this.
both sides, it seems to me, both sides were pretty perhaps sloppy about how they, your client was sloppy about how it calculated the amount owed. They were sloppy in not maintaining a copy of the lease or being more persistent in their request for one. But I am still troubled that they tell you that the equipment has been discarded and they tell you that they want to pay off the account in full. I don't understand how anybody could read that and not realize these people are not extending the lease, that they are terminating the lease beyond what they currently owe. They want to pay it off in full, and they don't have the equipment anymore.
Well, Your Honor, that may be so. That wasn't what it's not what the contract says. It's not a situation where everyone understands that this is what they want to do. The contract said written notice. Written notice was not given. And the fact that, everyone understood that maybe somebody would have or it was clearly in their interests to do that is not conformance with the explicit terms of the contract. It just isn't. I mean, these transactions are about written contracts between parties of equal, or in this case, if not superior, bargaining strength. This is what the contract says. We were in the Superior Court and in this court asking for enforcement of that contract. This is not a situation where when they got the payoff number from the lessor, they said, no, well, we don't understand how this is calculated, we don't this, we don't that, or here's your check, et cetera. So I don't see this as their having performed what they were obligated to do under the contract.
So why is the judge wrong on liquidated damages?
The judge is wrong on liquidated damages for several reasons. First is that there's no evidence for a number of the judge's findings. The first finding, probably the most important one, is the judge concluded that 18% was grossly disproportionate to a reasonable estimate of damages.
Well, who had the burden of proof, let me ask you that, on the enforceability of the liquidated damages provision?
Well, we submit that the proper rule should be that the party challenging the enforceability of the provision should have the burden of proof. As we pointed out on our brief, there doesn't appear to be any controlling precedent in the Commonwealth. There is the First Circuit case in which the First Circuit concluded that this court would rule that the lessor has that, but there was no evidence to support the judge's findings. If you look at, for example, the evidence regarding the software, and software was about a little more than 21% of the material listed. According to the expert, the lessee's expert, there's two types of software, transferable and non-transferable. And he conceded that transferable software had value, but offered no opinion whatsoever as to how much value it had.
But there wasn't there evidence that the judge accepted to the effect that there was a conversation between the principals. I'll use the word principals. I don't know if I'm using it loosely or not, but there was a conversation between principals to the effect that somebody at TAL said they didn't want the property back. Isn't that evidence that it has no value?
No, I don't think that that's a fair inference.
Somebody doesn't.
And this is a statement that after the property is gone, as Judge Sossman pointed out. This property can't be returned. I mean, that's
yeah. But the conversation was, if I had it, would you want it back? And the answer was no. And the judge accepted that testimony as true.
And I take it TAL is really is in the financing business. It's not in the used computers or used furniture business. It doesn't expect that it's going to get this stuff back.
No, I can't agree with that. So. It's not in the used computer and used furniture business. You're certainly correct about that. Yeah. But TAL Financial provides leases where it does take the equipment back, and leases where they are true finance leases, and the.
Is that in the record?
Well, in this case,
certainly this transaction is one where there was no right whatsoever on the part of the lessee to acquire this equipment. The unequivocal obligation was to return the equipment at the end of the lease term. So at least to the extent of these schedules, Your Honor, it is in the record that TAL does engage in that type of business. Otherwise, I'm not sure. I would have to go back and look at Mr. Siegel's testimony when he described.
Is Kelly v. Marks the law of the case on this issue?
Well, it's certainly true that the Uniform Commercial Code provision was not brought to the attention of the Superior Court.
Was Kelly v. Marks argued by both sides below?
Yes, it was.
Okay.
Kelly v. Marks
so
was.
It's fair to say it's the law of the case.
No, I'm not sure I agree with that. I mean, the issue of liquidated damages was clearly and presented to the judge. This is not a situation where the failure to cite the Uniform Commercial Code provision in some way influenced the evidence or the facts that were presented to the court. It's a full evidentiary record, and I submit that this court, an appellate court, can apply the proper rule of law. I think it's more analogous to a case not being cited to the court below. You certainly can rely on the case on appeal. What you can't do is raise a new issue that wasn't presented to the court. The liquidated damages issue was presented to the court, was fully litigated.
Can I ask you, if I don't know who will, but assume that we affirm the judge's rulings on the amount of damages that were owed, that the liquidated damages were properly struck. How is it reasonable to award your client attorney's fees when the plaintiff offered you the amount you ultimately got before you even started litigation?
Well, Your Honor, the contract provides to prevailing party, or provides for attorney's fees in this case. There was substantially more at stake than what the judge calculated to be the damages here. And I think that the result obtained is only one factor. The judge certainly was free to take into consideration the fact that much more was at stake.
Much more was at stake, but again, but you lost on what more was at stake. You didn't get anything more than what apparently the plaintiff had agreed to pay before the complaint was even filed. It's a little bit hard for me to see as reasonable the attorney's fees that get expended when you get nothing more than what was offered before litigation was even commenced.
Well, Your Honor, I think it's probably fair to say that what what was offered was what was conceded, what was owed, and I don't think.
And that turned out, according to this judge, to be the precise amount that was owed.
Well, that's.
And on her analysis, again, if we affirm her analysis, that's the amount that was owed. And I gather it never got reduced to an offer of judgment or anything formal.
It never did.
But it was part of the record that this had been offered before litigation, right?
I believe that was actually put before the court in connection with the request for attorney's fees.
Okay. Yeah.
I'm not sure it was in the evidentiary record.
Mr. Singer, your time is up. Thank you.
Thank you.
May it please the Court, Andrew Griesinger on behalf of CSC Consulting.
Let me ask you one thing. Are you arguing that failure to provide the lease equals some sort of type of waiver?
I am arguing that failure to provide the lease as a matter of law, based on the facts found by the court, is a breach of the obligation of good faith and fair dealing. In other words, the argument that we are presenting is that at the time when the TAL knew that CSC didn't have the lease, it didn't provide the lease. At the time that it knew that CSC didn't have the lease, our contention is that triggered the obligation of good faith and fair dealing.
How can you claim that you didn't know the notice provisions of the lease till the plaintiff provided you with the lease? Onward, which was your predecessor company, had a copy of the lease, and isn't it their obligation to provide it to you?
Onward was acquired by CSC. In essence, Onward became CSC. And what happened here, I think, was a confluence of events that happens all the time in the business world. Companies acquire other companies. Offices are moved. This is all evidence in the record. There was an acquisition of this company. The offices moved. The people left the company. So it happens all the time. We know in this century that there is such a movement of people and places and offices that it is certainly likely and possible that contracts get misplaced. We don't know what happened to the contract.
So
but
could you
not
have
it?
Could you not have written to the plaintiff and said that, we can't comply with the lease's provisions until we have a copy of the lease?
The trial court's specific findings were that CSC repeatedly asked for the lease orally.
Orally.
And that's important because I think the oral request for the lease triggers the obligation of good faith and fair dealing. In other words, you shouldn't have to jump through any number of hoops to demonstrate that the other side has an obligation of good faith and fair dealing. The obligation of good faith and fair dealing is an affirmative obligation that should arise once the other party knows and is informed that it doesn't have the contract, that it has no idea how to exercise its contract rights, and that it doesn't know what its contract rights are. It seems extremely basic that one party cannot deprive the other party of the rights to its contract by failing to allow that party to even know what its contract rights are.
But every day, consumers, not just big companies, people get confronted with a bank or an insurance company. They're speaking to someone on the phone. They don't do what they said they were going to do. They don't send you the right form. They don't do something. Everyone knows you then put it in writing, make a copy of the letter, and you send it if you really want the item or you want it done. This is not some unusual practice.
And the Superior Court judge found, I believe, that you were a sophisticated business entity. So you know about leases, and you know that lease provisions require strict compliance if you want to give notice.
There were a series of oral requests, and there was a written request. And this is the letter that was referred to by Justice Sossman, where there was a letter sent stating specifically that CSC wanted to terminate the relationship, it wanted to know what the payoff figures were, and it wanted the necessary information. Now, in response to that letter, CSC received a letter that didn't provide that information. And there was, by the way,
next step.
I'm sorry?
Next step. When they got a letter that didn't provide the information.
Sure. The case would be better if a letter was written. But the issue here, I think, is what should trigger an obligation of good faith and fair dealing, and how much do you have to say to get to the point where the other side has to act in good faith. If someone calls me up and says, I don't have a copy of the contract and I have it, of course I'm going to send it to them. And I'm going to send it to them the first time. And I don't have to get a letter because I know it's my obligation in good faith to send that contract. There's no dispute about that. I know that. And TAL knew that. It knew that we were leasing items we didn't have. That's in the record. It knew that we were asking for even what was in the lease. We didn't even know what was leased. And we didn't get that information until they finally sent not the lease, but interestingly enough, what they sent were the UCC financing statements, which, of course, provide a list of the items that were leased, but don't give you any information at all about what the lease terms are. Now, is that bad faith? We're not arguing that it's bad faith because I think under this Court's decision in the Uno Restaurants case, what you really just need to show is a lack of good faith. And that is a lack of good faith. In other words, when getting requests, they're taking advantage of this, yes, large, yes, sophisticated company, but that is dealing with lots of different things in their accounting department by, in essence, not providing the information. And does CSC know that there's an automatic renewal provision in the lease? They don't know that. Do they know there's more than one schedule in this lease? They don't know that. Have they been told what the term is, whether it's 36 months? They don't know that. They don't know anything. They were asking for this information, and they weren't provided any information whatsoever about what this contract provided. So they had no way of knowing whether it was a 6-year lease, a 3-year lease, or how to terminate it. So they were left completely in the dark after having made requests. Could they have made more requests? Sure they could have. You could always do more. But there was enough done here to put TAL on absolute notice that they wanted to terminate this relationship, that that CSC didn't have the contract.
Was it absolute notice they wanted to terminate? I mean, I just seen the judge's opinion, the sort of reference to the letter. It didn't say, at this point, we intend to terminate the lease. Please send us a final bill.
It didn't have the magic word terminate.
Yeah, it says we want to pay up the account. I mean, yes. I say that all the time. I want to know how much I owe so I can pay it up. That doesn't mean I'm terminating my credit card or terminating
But it
my
said
ring.
final payment, I think. It said we want to make this, we want this over.
Payment in full.
Yeah, payment in full.
Pay the balance of the account in full.
Which would make it over. Now,
well, I mean,
as Justice Sussman indicated in her question previously, TAL knew that CSC didn't have this equipment. TAL knew, and it's in the findings of fact, that its president was told they were paying for items they didn't even have. Now,
sounds to me like it's a very good reason for CSC to be all over this issue. It doesn't seem to me that they really were all over it. They were, well, could you send us a balance? We'd like to pay it in full. I mean, it doesn't sound to me that you were, as the judge suggested, really on top of the issue. You didn't take it that importantly.
There were a number of steps taken, but again, I think this goes back to my point, which is that how much do you have to prove you did before the other side has an obligation of good faith that's triggered? And I
Did you appeal that?
Submit, Your Honor.
Have you appealed that?
Yes.
Well, maybe I misunderstood. Yes, I thought that you were not appealing the $9,000 damages figure. No. So the extension up to the total of 4 years is not appealed.
Right. Right.
In fact, the only thing you're appealing is the attorney's fees award.
There is a cross appeal filed, and the issue could be, for example.
But you haven't briefed you haven't claimed in any argument in your brief that the judge erred when she said that your earlier letter in March of 2001 should have been construed as a termination of the lease agreement.
That is briefed, Your Honor. That is in our brief. In other words, there's a section in our brief about that and saying that letter put them on. They knew. They had actual notice that we wanted to terminate, and that is in the brief.
What is the judge's I was trying to understand what she meant at the very end of her decision, where she said, the plaintiff, however, waived its right to claim that the schedules were extended beyond 48 months when it elected to declare a default. What was the theory of waiver?
Your Honor, I think that's an excellent question, and I
let me just
I
add
have a theory. But
Yeah, let me just add. She did not articulate any theory that the return of the lease or the furnishing of the lease on August 17th of 2001, after some of the lease renewal schedules had gone into another cycle of one-year periods, constituted a waiver of the right to declare a default.
She didn't explain what she was thinking when she made that ruling. But this is what I submit that she must have been thinking, because there was a motion to alter and amend the judgment, and she didn't allow it. So I don't think she concluded that she just made a calculation error or made a mistake. The default letter itself, which was sent in September, states that, in essence, they're exercising the remedy of accelerating the lease, and it states specifically that it refers to an automatic renewal for it gives a beginning date, and the end date is September of 2001, and that was the date the letter was sent. So the statement in that letter that we are declaring a default pursuant to the automatic renewal that occurred through September 2001, the judge must have concluded meant that they were waiving any right to claim that the lease is extended, for a full another year, because they specifically said September 1 in that letter. Now, could the judge have explained what her thinking was more? Yeah, certainly. But that's what appears to be the basis for the judge's decision on that point. Now, the whole issue of the obligation of good faith and fair dealing, of course, does arise because it may not be, and I don't think we know this, that the judge was really focusing on TAL here is claiming they're wanting this whole extra year, from 48 months to 60 months. And that gets back to where the judge said it was a close call. So that is argued in our brief in terms of let's say, I think as a matter of law, based on the exact findings of fact that the court made here, that the obligation of good faith and fair dealing is triggered, and you cannot extend the lease beyond 60 months, to 60 months, in other words, from 48 months to 60 months, because of TAL's conduct in this instance. But the point, I guess, would be that if the judge, if this were, and this was all brief, the reasons for the obligation of good faith and fair dealing, if this went back down to the judge, obviously the question would be, well, Your Honor, address the obligation of good faith and fair dealing question in the specific context of whether we're going from 48 months to 60 months. And it's hard to tell from reading the judge's decision whether she was just deciding, it's only going to 48 months, and you haven't proved enough to say that it should be terminated as of 36 months. So I don't know if I'm making myself clear enough, but the point is that the obligation of good faith and fair dealing here is in the context now on appeal of the TAL, I think, attempting to have this court issue a decision that could have, I submit, troubling implications, where parties could start saying, well, the obligation of good faith and fair dealing hasn't been triggered here because you haven't proven that you did this, you haven't proven that you did that, you haven't proven that you wrote this letter demanding this, you haven't proven that you did these number of things. And I don't think that this court has ever held that the obligation of good faith and fair dealing requires a party that is claiming the breach to satisfy some sort of burden that they have actually done enough to almost compel the other side to act in good faith. The obligation to act in good faith, I submit, should be a voluntary action that a party should take on its own initiative when there are sufficient facts to show that that the obligation has been triggered. And here the facts are sufficient, as found by the trial court, to find that the obligation has been triggered. I see I'm running short of time. I'll just, if I can, just briefly address the liquidated damages issue. I think the court has indicated that the Kelly v. Mark standard is the standard in light of what happened below. That was the only standard that the parties addressed and that the court addressed. And under that standard, the trial court made, in the conclusions of law section, I think, some findings of fact, and gave 4 different reasons why there wasn't a reasonable estimate of what the damages could be at the time of contracting. And Kelly v. Marks got away with the second look doctrine, so we do look at the time of the contracting. I think the evidence of what the president of TAL said when he said, no, I don't want this equipment back, even if you had it, indicates that he knew all along that there wasn't any value. But I think more importantly, one of the facts in the record is that the lease payment stream requires you to pay the absolute full acquisition cost within the first 36 months, plus I'd call it an interest factor of about 13%. So under the way they set the rent here, you're paying, it's like you're buying a car, you're paying the full purchase price and interest, and then you're being said, oh, well, wait a minute, I've got a liquidated damages provision that says you owe another 18% over and above that. The lease payment provisions in and of themselves provide the adequate remedy, and you don't need to tack on another 18%, which it turned out under the evidence was just a provision that a lawyer stuck into the contract not knowing what was ever going to be leased, and this was a financing company.
Were there UCC filing statements in this case? Is that in the record? Were there
Yes.
UCC filing
In
statements
other
on
words,
these leases?
As I said before, when they identified the property, they sent us the UCC filing statements. So that was in evidence in the case in the form of this is what they sent us to tell us what it was that we were paying them for.
Thank you.
Thank you.
All right.